SJC-10726, Commonwealth versus Seino.
Good morning, Your Honors.
Kelly, good morning.
My name is Brian Kelly, and if it pleases the court, I'm here on behalf of Carlos Seino. The issues before the court, unless the court, of course, takes me out anyplace else, deals with the prejudicial error in allowing substitute witnesses to testify as to the results and facts of reports that were done by the initial analysts in this case, and from both a DNA standpoint and from the medical examiner standpoint, the autopsy and the death certificate. The second portion is actually a 1A and a B and a 2 to my arguments here. The second full argument goes to the improper admission of the results of another analyst who takes all of the results from a different laboratory and also brings his own conclusions as to that. The question initially is to the standard of review on these particular cases. There is a litany of these substitute expert cases that was cited from Nardi to Barboza to Avila to McGowan, all of these cases, and all of them seem to have one thing in common: they didn't object properly. This particular case is in the line of the case of Durand, which was properly objected to. As I stated in my brief, I concede that there's no question that any of the substitute witnesses, expert witnesses, had the absolute right to give their opinions as to that. There's no question at all. That's been established. The issue is to whether being able to bring forth the actual results. And in this particular case, I would argue that the objections were proper in both, mainly through the motions in limine that were brought, obviously, and were argued just after the impanelment of the case. There has been recently, you've seen the new case brought down by my sister counsel, Santana, that basically for the premise that the Grady case, which I did cite in my brief, is not a retroactive case. And my response to that is, in this particular case, after reviewing it at all again and kind of establishing again, I think that's right. It is. It's not a proactive case. However, this particular case, Grady was actually an upgrade of the case called Wellington, which is 428 Mass 24, and in particular cited it.
But here we had a motion in limine and plus objections at sidebar.
Yes. Yes, they were everything. Well, all three, Your Honor. There was the motions in limine brought by the Commonwealth and by the defense counsel. There was also the argument, which went on for about 25 pages of transcript from, and if the court, for the court's own edification, that the transcript of the colloquy between the counsels and the judge was volume 1, pages 199 to 124.
Can we get into the details for a moment?
Yes, Your Honor.
Maybe start with the autopsy and the testimony of Dr. Evans. So, as I understand it, your view is that Dr. Evans is a substitute medical examiner.
Yeah, everybody in this case was a substitute, Your Honor.
Right. No, and there was a delay in the return of the indictment, but put that aside. So, Dr. Evans, he testifies as to the cause of death. That's
right.
That's not contested.
Yes, actually, it is in a way, Your Honor, because there were arguments made at the, during the motions in limine stages, at the, I believe also at the motion for required finding stages, and at the end by defense counsel, that there were three medical examiners involved in this case. The first medical examiner was Dr. George Benjamin, who comes in at the scene. He doesn't touch the body, but he saw the body. And he suggested that there was asphyxiation due to, I guess, a broken nose of the decedent. And he also makes mention that he sees no indication of robbery. Dr. Cherkoff, who is the actual medical examiner who did the autopsy, comes in, and if you look through the not only his testimony, but how his testimony is characterized by the prosecutor, because the Judge Chernoff asked him specifically, well, does Dr. Evans, first he asked, did Dr. Chernoff have a cause of death? And the answer from the prosecutor was no. And then he said, well, what is Dr. Evans going to tell us? And he says, well, he's going to tell us there was damage to the decedent, the back of his head, the front of his head, and there was also a concussive injury that involved the asphyxiation. And he can't tell us really which is which. In fact, he used the term, it's the chicken and the egg. And
But there's no issue, though, that it's a blunt force trauma. That's really not contested.
That was brought up and I believe objected to by trial counsel when there was somebody had written down homicide, they scratched that off.
I'm not talking about the death certificate.
No, but I believe defense counsel does object, well, in a sense, objecting that should have been in the death certificate. I would suggest to the court that that's a contested part.
I'm just trying to.
Yes, Your Honor, sure.
I don't want you to run out of time here. Your
Right.
point is that what's going on here is that Dr. Evans is testifying as a conduit for somebody else's opinion, and that information's coming out on direct that was not admitted in evidence appropriate.
Correct.
Okay, so that's your argument. So you've got a trooper, a lieutenant in the autopsy, right?
Yes.
Okay, so the lieutenant takes photographs, and Dr. Evans relies on the photographs as it relates to the parallel laceration.
Yes.
Right? All right, then you've got Dr. Evans actually at the time of the autopsy, not later, right at the time, reviews the report and signs the report, right?
I believe he does sign the report. I can tell you, he never saw the body.
He reviews the handwritten notes, the toxicology reports, examines the cuttings of the brains with the lacerations, and he comes to his own opinion that it's blunt force trauma. He takes into account the toxicology report with the 0.28 blood alcohol, so he's got all of this information.
That's correct.
And then based on that information, which is all admitted in evidence. I know that there was some parts that were not admitted in evidence but.
Well, none of that should, well, his opinion, yes.
Everything I've said was admitted in evidence, so. And he gives an opinion based on that. Certain should not have been admitted on evidence on direct. I
Correct.
agree with that.
Correct.
But what I just listed is admitted in evidence. Based on that, he gives an opinion as to the cause of death. That's not really contested. Where's the error?
The contest, Your Honor, is as trial counsel also argues, as I said, at the required finding stage and at the end, was that there is nothing as far as how everything happened. There may have been blunt force trauma. Again, she does object to that, but the fact is that as far as which came first, what was the actual cause of death? They're not, there was the question as to whether if this person was hit on the back of the head with something and then he fell, what caused the death? Did he fall first? Did somebody hit him afterwards? All these scenarios were put forth to the trial judge, Your Honor, from defense counsel.
But you agree, there's a difference between contesting how it happened and what the injury was.
Well, there was a blunt force trauma. Agreed with that, Your Honor. Okay. It's a matter of what happened. When was the blunt force trauma, as the prosecutor fully admits? I can't tell you what caused the death.
Can we, I don't know if we've done with this topic, but can you answer the prejudicial impact of the DNA charts? Because so many of our cases deal with these charts that have improperly come into evidence. And here, I think it's probably tough sledding to say that Robin Cotton couldn't testify about what goes on in Cellmark, But we have the DNA charts in, I think, 3 or 4 instances.
Right.
And why is that prejudicial?
Well, it's prejudicial, Your Honor, if you look at the entirety of the case. The only thing that points to the defendant is DNA. There's no eyewitness. There's no time of between 1 a.m. and 7 a.m. is the time of death. As I said, we even though we have the blunt force trauma, there's still as to what happened, where, who hit when. Defense counsel actually makes, somebody could have hit this person and somebody else could have robbed him. One of the points that was I believe made was the fact that there's not even evidence conclusively that there was a robbery. This man lived 5 minutes between the library, the bar, and where he lived, and he's gone for 6 hours. Nobody ever checked to see did the man ever go home, put the money away, and then go out he could have been walking in the morning and gotten hit.
Justice Gaziano's question is,
Yes.
is Dr. Cotton's looking at the raw data from the electropharogram.
Right.
And so from that raw data, there's charting. What's the prejudice? That's
The prejudice,
the question.
the prejudice, Your Honor, okay, this I argued in the brief, goes beyond I believe it was Barboza, which this court came in and said, DNA is DNA, and it's how do you get around that essentially, and the language I believe this court used was the only thing that you can't, basically the only thing that you can challenge would be any type of fraud or incompetence in this particular case. I mean, I fully admitted in the brief that Judge Cotton, I think in the Grenadier case, was fully vetted. They claim she's the best person you could have had for this job, and again, I conceded that. But the point is that past the Grenadier case, all of a sudden everybody became aware of how certain people who are testing things can finagle them, shall we say, a la Annie Dukin. That's why I raised the Scott case. Just Dr. Cotton can in no way testify whether anything was done fraudulently. She didn't.
Could Cotton testify that there was a match?
Yes.
Based on what you view, but she can't testify at this allele there was this result.
She can read. She read it.
Right, which is improper.
But she read. I mean, I know this court has said in the past that without that, without the profile numbers, the alleles aren't. I never understood that one, but that's
right.
okay.
That's Matai, right?
Right, and actually, Dr. Cotton doesn't give any profile. She just goes through the numbers. She's the only one of the experts who comes in and does not give her own profile. The profile is actually done by the gentleman in Texas.
Okay.
I do want to, because I see my time is cutting short, so I do want to make sure I get one thing in as far as the autopsy report. Defense counsel raises the issue, and it's analogous to bullcumming, in which the original medical examiner was fired for unknown reasons. The substitute examiner the substitute witness, I should say, comes on, and the court acknowledges, can't tell you why, have no reason why, don't know what it is. And the Bull Cumming case came out with a couple of things to address this issue. And I raise this issue because that's exactly what defense counsel questioned when objecting to this medical examiner coming in. I don't know why this person got fired. I don't know if it's because of incompetence. We have no idea. And the Bull Cumming court, and I specifically tell this to the court because I didn't quote this out of the case in my brief, but basically they said if an analyst, they said in the rare case, no longer works for the government, it's up to the prosecutor to make every effort to bring that original analyst in. Fair enough. If you look closely at the colloquy that went on between the prosecutor and the judge, specifically it's at transcript volume 1, page 221, lines 9 through 12. The prosecutor first suggests, well, the defense counsel wanted him so badly they could bring him. And the cases have said, well, it's not up to the defense counsel to grab every accuser, especially if it's an analyst. It's up to the prosecution to make their case. But the prosecutor in this particular case specifically admitted that I didn't call Dr. Chernoff. He knows where he is. In fact, defense counsel says she didn't know where he was till a week before the trial. He says, I didn't seek to call him myself for the obvious reasons that I don't think he's sympathetic to my cause. And I would say, if there's a situation in which defense counsel is specifically saying, I have to be able to talk to this person. Melendez-Diaz says the cross-examination is designed to weed out not only the fraudulent analyst, but the incompetent one. In this case, it's not Brian Kelly making up a new theory. This was the case that the trial counsel originally raised.
You've got a bunch of different themes going on
I do.
within that. And so just separate them out for a minute.
Yes, sir.
Look, if the prosecutor felt like Dr. Chernoff, if he had exculpatory information, then that's a whole other argument that's not in your brief, and that could be very important. But the issue for us is whether or not, based on Commonwealth versus Tassoni, whether or not this medical examiner, Dr. Evans, could be fully cross-examined, and whether or not there was a basis for his opinion. And the fact that the Commonwealth didn't summons in the medical examiner, as long as there was a basis for the opinion that came in, that's not an issue that raises a testimonial confrontation clause issue. That's an issue of whether or not exculpatory evidence wasn't provided.
Well, in other words, Your Honor, trial counsel could not confront the witness, the actual person that testified, as to issues of veracity and competence. It specifically raised that at the motion in limine. And the defense, I think I said prosecutor, the defense.
You have to frame that as a Commonwealth versus Tassoni argument, that you couldn't reasonably and effectively have an opportunity to cross-examine Dr. Evans based on the situation. Maybe you have that.
Well, you can't, what I'm saying, Your Honor, is a la Bull Cumming, he can't know why this person left. And in fact, it seems to say, and again, I can only say it seems to say, that the prosecutor is saying he's not going to be sympathetic to my cause, so I didn't bring him, which I would say raises the whole confrontation issue. You're purposely avoiding the one person that can answer the question that defense counsel is asking the judge at motion in limine, or explaining why this person is not going to, Dr. Evans is not going to work for me. And then the prosecutor fully admits, I didn't, I didn't want to bring him. And at that point, as far as harmful error, we can't know whether there was anything wrong with the statistical numbers because we can't have them. And I just see my time is up, Your Honor. So if you have any further questions, I'll entertain them, of course, but
All right.
I'll rest on my brief.
Thank you.
Thank you.
Thank you, Your Honors.
Ms. Alford, good morning.
Good morning, Your Honor. Pamela Alford for the Commonwealth.
Before you get all wound up into your argument.
Yes.
I mean that well. This case was tried in June of '08.
Correct.
Nardi was decided in September of 2008.
Correct.
And I'm trying to think as to what our case law looked like on this issue before Nardi, because Nardi was the first autopsy case where we had to deal with this issue, I think. What was the state of our law that Judge Chernov was dealing with in June of '08 with regard to these issues?
The state of the law is cited in the Commonwealth's motion in limine, which is in the defendant's brief in the record appendix at R17. He cites Walker and Lineback, which are appeals court cases, and Sparks, which is an SJC case for the principle it's proper to admit director of forensic laboratory to testify on independent review of the data. But I think Your Honor's point is well taken. The parties, and I think this is, we need to look at what the parties knew and didn't know when my brother focuses a lot on what the prosecutor says when trying to puzzle this out. We need to look at what came into evidence at trial because the parties did not have the benefit of Nardi, did not have the benefits of Barbosa or McCowan or Tassone. And yet, I suggest that the prosecutor and the judge and defense counsel were prescient in many of the issues. And if you look at particularly the DNA evidence, you had a supervising personnel from every laboratory that analyzed the evidence. And you had robust testimony from the criminalist that took the stains. And to start, Your Honor, with the Tassone question, there was a minute detail every step of the way, I would suggest over and above what even today this court requires, of how the defendant's blood was analyzed and how the front left pocket red-brown stain was analyzed, that you had the trooper that saw the victim at the scene, who took pictures at the autopsy that were properly authenticated, testified that she took the clothes went to the Mass State Crime Police Lab. Kerry Donovan, the criminalist, took a cutting and then snippets of the evidence, and I suggest Donovan's testimony is critical for a couple of things. One,
Before we get really into the substance, what you're getting into, can you answer Mr. Kelly's first question or proposition, and that is the standard of review? Because here it seems to me that defense counsel filed a motion in limine and objected constantly throughout the testimony. What else was she supposed to do?
the Commonwealth believes position is that there are two different standards of review for the autopsy and for the DNA. The Commonwealth agrees that where counsel filed an opposition or a motion in limine as to Dr. Evans' testimony, argued it, objected at the beginning of his testimony, and objected to the death certificate. The Commonwealth agrees, and it is in our brief, that that issue is preserved. But the DNA, the specific issue of the underlying numbers, was
she objected to a substitute witness in the DNA.
She did, and as this court has said many times, Massachusetts bifurcates the issue of what expert can testify to and the factual basis for that opinion. And critically, I would point to the factual record, which is the Commonwealth filed separate motion in limines as to the substitute medical examiner, as to substitute DNA witnesses, and that they want to get charts in of the DNA. And if on June 9th they argue the substitute medical examiner, they argue the substitute DNA evidences, and defense counsel has two basic arguments. One is she doesn't want the person testifying, based on work they did not do, and that she doesn't want them agreeing with other findings because it might bolster the credibility. She does not argue as to the underlying factual findings. At the conclusion of that argument, they talk about unobjected to motions, and the prosecutor makes a comment that he has a couple of motions. One is the DNA charts that he doesn't believe that counsel objects to. And he says, well, I don't want to speak for her, and nothing from defense counsel. And the judge, critically, if you look at Grady, which I'll get to in a minute, says, well, we don't have to address it here. So clearly this was not resolved. At the beginning of Dr. Cotton, who was the first, I would call, substantive DNA witness. There was one other DNA witness, Brian Cunningham, who testified as to a third-party sample that was eliminated. So he says, well, I have these charts, and defense counsel doesn't object to the data, she objects to the size. She objects to the reference of CODIS. And they talk about whether they should use smaller ones or white it out. The judge says CODIS didn't apply to the defendant. There was no defendant at this time. The Cellmark dealt with, in 2003, Cellmark developed a profile of the right-left gene pocket sample, which was a red-brown stain. And when he puts in Dr. Cotton's report, there's no objection. So looking at Grady, the Commonwealth's first position is that Grady does not apply here. There is language in Grady which suggests that it's prospective. And I acknowledge this court's opinion in Inree Green and in Commonwealth versus Santana, which I cite in a 16L, that applies Grady to a case that happened before Grady without addressing the issue of whether Grady should apply, and then says, basically, Grady does not apply here, not because it's prospective, but because they didn't specifically raise the objection. Well, I make both arguments. One, Grady doesn't apply to a trial that happened 8 years before, given this court's clear language. And two, if Grady does apply, defense counsel simply didn't raise the issue of the underlying numbers of the charts. In fact, she used the issue on 2008 testing by Laura Bryant of lab work which was done by Sidney Collins and an analysis which was done by Laura Bryant. Defense counsel has her go through the raw data in an attempt to show that there was a third party on the swabbing of the genes.
Were the charts admissible?
The Commonwealth does agree that underlying numbers should not have been, that the charts in their precise form were not admissible.
So that was a yes?
Yes. Okay. But looking at this court's opinion in Sanchez, each witness came to their own conclusions about the profiles generated in the matches made. In Sanchez, there was a case where a substitute witness made her own charts based on her own conclusions, and this court said there was no error in that. So looking at the nature of the error, where the witnesses specifically testified they came to their own conclusions, there was no prejudice here.
That's an important point. I just want to make sure, just go back to that for one moment.
Yes.
If you have the person on the witness stand, the DNA analyst on the witness stand, who looks at the raw data, that actually is right there from the electrophoregram as the DNA is separated, and then that person charts the alleles at the various loci. The chart's admissible in that circumstance.
Under Sanchez, I would agree with that, Your Honor. And I want to address 2 points, one in Dr. Cotton's testimony and one in Laura Bryant's testimony. The first is Dr. Cotton does not testify that there is a match. What Dr. Cotton testifies to is that in 2003, they received 2 samples from the Massachusetts State Police Crime Lab. A red-brown stain from the front left pocket of the victim's genes, and also inferentially the victim's blood standard. That they get a profile, and she goes through the electropherograms, one page which was marked for identification. Dr. Cotton says that she came to her own conclusion, that she looked at the data as it came off the machine, and they were able to get a mixture. And then she testifies as to her own conclusion that they were able to get a deduced profile, that they were able, that because of, not because the report told her, but because looking at the data, looking at the electropherograms, at the strength of the signal, and at the different levels of peaks, that there was, that looking at this particular data, that you could deduce a profile, taking away the victim's DNA, and getting a deduced unknown male profile. This was in 2003. There was no defendant at the time. I do note, just for the record, that the report does include statistics. They weren't testified to at trial, that would be considered more that would be more defendant favorable than the statistics that DuPont testified to, because looking at that report, that would be the statistics for all DNA types, so not deduced. All DNA types that could have contributed to the mixture. So that's in 2003. When the defendant gives a saliva sample in 2006, and again, there is testimony of who took that sample from Trooper Moran, that Trooper Moran took it to the State Police Crime Lab, that Kristen Sullivan, who was supervisor and who was the technical reviewer, who had reviewed it all at the time, that she deduced, deduced is not the right word, that there was a profile produced, and that was sent to Selmark, Texas. And Matthew DuPont then testified that there was a match between the two profiles and testified as statistics. That is the relevant and probative evidence that was before the jury, and that evidence was absolutely properly admitted.
So to just go back to that point, because it sounds bad when you hear that somebody from Texas is there comparing the known sample to the evidentiary sample. But what you're saying is that Sullivan sends the known sample that she actually takes from the raw data from the buccal swab.
Correct.
And that she sends that to Texas, and they also send to DuPont the evidentiary sample from the clothes. And
correct.
that he compares those two, and then he's in Massachusetts at trial and testifies to the 1 point whatever quintillion it was.
Correct. And the critical difference between this case and Tassone is that Tassone talks about the language in Tassone is where an opinion that DNA found at the crime scene matches the DNA's profile is offered by an expert who is not affiliated with the laboratory where the testing of the crime scene DNA sample was conducted, and where no analyst from that laboratory testifies regarding the testing, a defendant is effectively denied the opportunity to explore through cross-examination wherever the opinion was flawed. We had those lab personnel. We had Dr. Cotton. We had Kristen Sullivan.
DuPont doesn't do any testing. He reviews raw data, or does he? Or
Excuse me, DuPont?
Yeah, the person in Texas, what's his name?
DuPont, Matthew DuPont does do testing of several elimination samples. He does not do testing of any sample that produces statistics.
So he looks at the results from Germantown, Maryland, right?
Which was closed at that time.
Right.
Right.
Okay, so it goes to Texas, then he takes the Mass State Police data,
Correct, the profile.
and then he compares them.
And if you look at Grenadier, that was perfectly appropriate, that only an expert could create a statistical significance for the jury and testify to that. And that's what he did based on properly admitted testimony from Dr. Cotton and Kristen Sullivan that they produced profiles of the defendant's known saliva standard in the red-brown stain on the front left jeans pocket. And I
Also comes out to be the same statistics as Bryant's testimony, right?
Well, Bryant testifies as to a different stain.
I know, but the profiles and the statistics are
I
very,
don't,
very similar. That's the supervisor from the DNA unit in Massachusetts.
right, so Laura Bryant, she testifies as to a profile of the red brown stain. Whether they're exactly identical numbers, Your Honor, I couldn't tell you. Laura Bryant had the benefit of doing identifier testing. So Laura Bryant's testing, and so identifier testing was testified at trial that there were 2 additional loci used. So she did her first round of testing in 2006 and her second round of testing in 2008. And the major point I want to make about Laura Bryant's testing is that there has been a lot made that Laura Bryant tested a swabbing of the front left jeans pocket of the victim, and the defendant contends excluded the defendant. There are several points to be made about this. First of all, this was not a mixture. Laura Bryant testified that it was a partial profile that came back to the victim and did not come back to the defendant. Additionally, here, the jury had the benefit, again, of Carrie Donovan's testimony, who was a criminalist, who very carefully showed the jury how she first took the entire sample of the red-brown cutting, that she cut it out, and that would be 2-9, I believe 1.1, or 9.1, and then she later took a swabbing of all the pockets, and I believe that would be 2.9.5. And she showed the jury with a chart that was admitted into evidence. I believe that's either Exhibit 51 or 52, showing a picture of the victim's jeans, of exactly where she took the cutting and where she took the swabbing. So there's just nothing contradictory about those 2 pieces of evidence. Second of all, a point that the defendant raises in his brief, that Matthew DuPont didn't know where the sample was taken. What Matthew DuPont testifies was that he wasn't asked to do serology testing, so he couldn't tell whether the sample from the victim's jeans front left pocket was blood or saliva. One, you had Dr. Cotton there, and that question could have been asked of her. There is no suggestion she would have given any different answer, but more probatively, you had the criminalist, Carrie Donovan, there, who did blood testing, did serology testing, and testified that red-brown stain was human blood. So the defendant simply wasn't denied his right to cross-examine any of the components of the statistical significance of his DNA on the center of the victim's shirt and on the red-brown stain on the victim's pants. And
if you really dig at what you just went through, that's an authentication issue. It's not a confrontation clause issue. You get from Donovan, gets the materials down to DuPont, and DuPont makes the match. And when DuPont's asked that question, that's an authentication issue, not a confrontation clause.
correct. It actually, Donovan gets the materials to Lynn Sardi, who's from the Mass State Police Lab, who testifies she mails that material to Cellmark, Maryland. And then Dr. Cotton from Cellmark, Maryland testifies that her lab, which she was lab director at the time, produced a profile and then produced a deduced male profile from that evidence, which eventually, several years later, goes to Cellmark, Texas. And Cellmark, Texas then Matthew DuPont testifies as to the statistical significance.
What I'm trying to say is the lack of being able to get an answer to that question of DuPont on cross-examination, that has nothing to do with the confrontation clause. That's
Absolutely.
an authentication issue if you dig at it.
correctly and the Commonwealth properly authenticated that evidence. I see I'm running out of time, so I do want to briefly address the autopsy and what was correct and not correct about Dr. Evans' opinion. Dr. Evans, I suggest there was no better person to testify as a substitute witness. Not only was he the chief medical examiner at the time, but he signed the report. Not only did he sign the report, he examined the victim's brain as part of his specific expertise in neurology. Dr. Evans' opinion that blunt force trauma was the cause of death was perfectly acceptable. And it is in the autopsy at record 35 that Dr. Turkoff did say blunt force trauma was the cause of death. The autopsy suggests this is very important and shows that there could not be any possible prejudice.
The measurements were inadmissible.
The measurements were, I agree the measurements were inadmissible, but the defense counsel used those measurements to show the unreliability of Dr. Evans, who signed the report. There is extensive cross-examination that Dr. Evans, that of the length of the wounds, which I suggest she then used to show that the wounds were so slight that the defendant could not have, that the defendant, who was a construction worker, would not have created them. In sum, Your Honor, Dr. Evans, any error as to the death certificate or as to the length of the rooms was totally cumulative to Dr. Evans' opinion that he was struck by an object, which was on redirect, and that his observations based on the properly admitted photographs of those wounds, which were properly admitted through Trooper Fabry's testimony. If there are no further questions, Your Honor,
All right, thank you.
I'll rest on my brief. Thank you so much.